very vital in our communities, but of course those that are very, very much helpful, of course impactful in our respective communities. And today it's a privilege that we are going to be having an extension of Know Your Rights, because every time we have Know Your Rights in our Rise family, it is always just 5-10 minutes. But today we are going to have quite a number of minutes discussing the succession law here in Uganda. And to be specific, we shall be talking about the testate and intestate succession in our country here, Uganda. So it's a pleasure that we are having. By the way, every Wednesday, I want to remind you that it is a partnership with the government. So we always have some person representing a government institution come here and discuss a number of things, because there are quite a number of things that we do not know from the government side, yet we are supposed to be knowing them. And of course, it is very vital, which is why we have that. To be specific, today we are going to be joined by someone from the Judicial Services Commission, and that is none other than Patra Alinda, who is a legal officer. Now, when I say legal officer, you know that we are really going to be talking about law here today. Good morning, Patra.
Good morning. Thank you for having me today. I'm glad to be here at Family TV. It's my first time, but I know that the topic we have today and the place where I am, it's the right place for us to have this discussion.
Okay.
Yes.
Oh, it's a pleasure to have you indeed. And now, before we go to the nitty-gritties of our discussion today, maybe if we can first look at the establishment of the commission itself, so that people know where you're coming from.
That's true. I'm a legal officer from Judicial Services Commission.
Okay.
So what is Judicial Services Commission? It is an institution created by the Constitution of the Republic of Uganda, 1995, with all its amendments. So the functions of the Judicial Services Commission, we advise the President on the appointment of judicial officers, right from the registrar from the High Court to the judges until the Chief Justice, the head of the judiciary. But the Judicial Service Commission also appoints judicial officers from the rank of Magistrate Grade 1 to the Chief Magistrate Court. We also recommend, we receive and process people's recommendations and complaints concerning the judiciary and act as a link where the people's bridge to justice. But most importantly, we prepare and implement programs for the education of the public on law and administration of justice, and that is why we are here today, to make sure that people understand certain basic legal principles on law. And the fact that we are here on Family TV, it is right that they understand legal aspects in relation to succession, which is a very important, it is one of the most common litigation areas. If you go around the courts in Uganda, I think after land, succession comes next. We have so many succession disputes, so I thought it right that having been given this opportunity, we look at testate and intestate succession today through Judicial Service Commission's mandate to educate the public on law and administration of justice.
Maybe one simple one before we proceed. When you're out there making these outreaches, making these community engagements, what level are we at when it comes to understanding the law with the citizens of this country?
What level are we at? At least the literacy rate has grown higher, I think 80%, but on legal knowledge, we are still lacking. Yes, at least people are able to speak, people are able to understand, but when you ask them the simple basic legal principles, we are not yet there. Yes, we are below 50%. Yes, so we need to continue to do these sensitization programs on the different topics that affect people, that are constantly affecting people.
So how do people reach out to you?
To Judicial Service Commission, we have our head office, which is actually very near at Kingdom, Kampala, just below UBC head office. We're on the 8th floor, but we also have regional offices. We have one in Bara, we have one in Masaka, and we have one in Moroto. So if you're around those areas, you don't have to come to Kampala to meet us. And you can also reach us through our toll-free line, which is 0800 100 222. Also, you can find us on our website, www.jsc.go.ug. So you can be able to find us in any of those you'll be able to reach us. We can be able to help you if you have an issue regarding the judiciary, but also if you want to understand more on the legal principles in regard to law and administration of justice.
Okay. All right. I think now you can unpack what you've brought for us in regards to testate and intestate succession.
Okay, so today we'll be talking about testate and intestate succession in Uganda. Someone out there may wonder what is testate and intestate succession. We know that managing estates in Uganda after death is a very complex issue. After someone has passed, we are wondering, this person had an acre here, what's going to happen to it? This person had a spouse, this person had 2 spouses, we recognize polygamy. This person had children from the marriage and also children outside. This person had dependent relatives. But most importantly, what is going to happen to this estate? How is it going to be transferred to the beneficiaries, who we shall later understand who are these beneficiaries. Not everyone who knows you is a beneficiary. So what is testate succession? It is the legal procedure for transfer of property from the deceased to his or her beneficiaries upon death, where this person had a will. This will must be a valid will. So where this person passed on and there was a will, and this will is confirmed to be a valid will, we consider that as testate succession. So that person is considered as testate and having died, testate. So where there is a will, we also need to ask ourselves, is this will valid?
Okay.
Yes. So it takes us to the next thing. We have the Succession Act, which guides succession law in Uganda, but it has had modifications, and the recent modification was in 2022. So these modifications have been able to provide for equality. Originally, there were certain things regarding women and men, considering our customs and traditions. But now we have girls taking on property of their fathers. All these have been recognized in our current Succession Act with its amendments as per 2022. Okay. So now where there is a will, we expect that a person, a father or mother, whatever capacity you are in, if you die and you have a valid will, you should include all children, regardless of their sex.
Okay.
So now those are some of the things that we shall look out for in a valid will.
How about the culture influence as well? Because you could leave your daughter as the heir, but due to the culture background of the society, she gets challenges along the way.
So any cultural practice that is against the Constitution of the Republic of Uganda, it is considered null and void. Because the Constitution of Uganda provides for equality. Men shall be considered the same as women. Okay. Even with property, even with succession. That's why actually our amendment has heirs. We never had someone, in Uganda is it called omska? Okay, for us we call it omska, where I come from. But we always knew that it must be a boy. So where a man had no boy, they would find the next boy in the family. But now, regardless of whether you have boys or girls, you can even consider your last child who is a girl to be. So all the customs must be in line with the Constitution of the Republic of Uganda and also the amendments that have now been put in place in 2022. Okay. So we implore the public that when you're handling these succession issues, do not say that they are for the men. Girls went and got married, they should go and find their property where they got married. No. For as long as someone has children, then they must be in the will. Okay. So a valid will, one, you must be 18 years and above. You must be of sound mind. Okay. You must have made the will when you were of sound mind at the time you made the will. But most importantly, you must have signed this will and you must have had at least 2 witnesses to confirm. Because you know the will takes effect after you have died. Before you have died, the will, it's not. It's there, and you can always change. You can change every day. You can add, because today you have property, tomorrow you add another property. Sure. For as long as you're living, have this will and then keep adding your property, and then at the end of the day we shall see, did this person include all his property? Did he or she include all the children? Did he or she have a spouse, and was the spouse included?
Okay.
All those things shall be considered to confirm whether this will is valid.
Even when you have two people, like you did say, the law now provides for polygamous marriages.
It has always, under our marriage law, customary marriage is polygamous in nature. So if you have only done Kwanjula or Kuhinjira, you can Kuhinjira as many, you can be Kuhinjired as many times. You can be Kwanjulad as many.
You can be Kuhinjired many times, like a lady.
No, the man.
Okay.
Yes. So he can go to different homes and be given as many girls as he wants. Yes. So we recognize polygamy from the customary marriage. Civil and church are monogamous, but from the, so that's why we recognize that if this person had two spouses, because two spouses, they must be married, not staying with someone, but you must be married. We need to emphasize also that for you to be a spouse, you must be married. Yes. So you also will be in this will.
Okay.
So those are some of the things that we look at to consider if
will is valid.
All
right. Then you did mention about sound mind. I've had some complaints, some reports coming in here and there. People do write their wills well on gunpoint because their children want to take over property, things like that, or even their spouses. How do you determine that this is not valid? How do you get to that point that maybe this person was forced to do this and this? Or it has to be them reporting?
That can be taken to courts, and courts will, using the evidence that you have submitted, they will guide. Because there is hearsay evidence, and then there is actual evidence.
Okay.
So if you have actual evidence, you can go to court and contest this will. Actually, you can contest a will before courts of law, and they will declare and say either this will is actually not valid. When you go to, once the person has died and you've gone to courts of law, they'll actually look at, is this will valid? Those are some of the things they will look at.
Okay.
Did this person make it when they were sober? Was there undue influence or not? Were they on gunpoint? That's why we have the whole requirement of witnesses. Who are the witnesses? And they must be at least two, not just one. So at least two people, and they must not be beneficiaries, because you know that the beneficiaries are going to put you on gunpoint. So it must be someone else who is not a beneficiary to this estate that is going to be transferred. So some of those things are considered by the courts when they are actually confirming that this will is valid or not valid.
Not valid. Okay. And then how about when these people do come in? There are some moments when you find maybe information has leaked and someone knows I'm going to be the heir to this property. Isn't that a problem?
Yes, we believe that a will should be secret.
Oh, yeah.
A will should be effective upon the death of the person, of the testator. The moment it's leaked, then it's not going to be effective upon death. So we expect, and there are different avenues you can keep the will that are provided by the law.
Okay.
You can keep it with your lawyer. You can keep it even with your bank. You can keep it with your friend who you know that will not tell these people.
Okay.
So there are different ways you can be able to keep it, but most importantly, a will cannot be effective
unless you're dead.
Okay. So we need to emphasize that also, that it is not effective until you're dead.
Okay.
And once you're dead, even when the will is there, we shall look out for its validity. Is it valid or it's not valid?
Okay.
If it's valid, we recognize it.
And maybe what entails a will? Does it now provide for typing? I was at a particular ceremony celebrating the life of the deceased, and they played a video. Is that all valid as well?
A will can be in writing. It should be in writing. A will can be oral, but only in a few circumstances. When this person was a soldier and they were on a battlefield. For example, we have people who go to Somalia, and the person is going and he's saying that, oh my goodness, I don't think I'm coming back. They can orally make their will.
Okay.
But except such circumstances, it should be written. It should have the name of the testator, the person who passed away, the beneficiaries, your spouse, if you have a spouse, if you have children, who are the beneficiaries, if you have dependent relatives, what property are you putting in this will? And you can put in any property except your residential home.
Oh.
Now, the residential home, we believe that this should not be transferred. The purpose of a will is to transfer property from you to the next people.
Okay.
So the residential property should be kept only for the spouse who was left at the time you passed on and the children who were using. You can only put it in the will if you know that you've provided another residential home for them.
Okay.
But without that, it should not be put in your will for distribution. Yes.
Okay, that's very interesting. So what can be disposed of in a will?
In a will, just like I had said, all property that belongs to you, including your money in the bank, including your pension, including your NSSF.
Pension.
Yes.
Okay.
But we believe that also pension is only for 15 years. So if you had retired and maybe used 3 years, you're going to deduct, and we'll have 15 minus 3, that's 12.
Yeah.
So we'll have the remaining 12 years. Your beneficiaries can enjoy your pension. They can enjoy your NSSF savings. They can enjoy all the property that you have, but a residential holding shall not be included in one of the things that can be distributed in your will.
Okay. All right, maybe one important one. How can the beneficiaries administer an estate where there is a valid will?
Yes, so we have a challenge in Uganda. Once a person has passed on and they have a will, people just go ahead and distribute the property. That is also wrong. Once there is a valid will, even the will, that its validity will be confirmed by court.
By?
The validity of the will shall be confirmed by court. So where there is a will, and first of all, you as the family members are not contesting it, you will apply to court for grant of probate. You will obtain the death certificate, attach the will, and then court will first look at this will. Is this will actually valid? Looking at the things that we have just discussed, and once it has, this will also must have an executor. This person must have named that this person will help me administer this will. Or this person will help me transfer my property to my children. Usually that's how people phrase them. I have appointed so and so to help me transfer my property to so and so. To my children, this and this and this and this.
Okay.
So all those things will be attached and given to court. You will give the information of the beneficiaries, and court will review your application and will grant you probate, and that is how transfer of an estate shall be moved from the deceased to the beneficiaries. But let the people of Uganda stop distributing property upon seeing a will. That is wrong. You must move to court, because now once the person dies, the estate moves to court. It's no longer, it's not yours. Yes, you're the beneficiaries, but you need the power. And actually there is an offense for distributing property of the deceased without grant of probate, even when you have a will. So courts have given us, and the law that was amended has given us 3 months. So you should use all those 3 months to organize yourself and apply to court for grant of probate to be able to distribute the estate, even when you have a will.
A will. Okay, very interesting. How about the other way around? What happens where there is a will but there are no executors?
So in Uganda, we know letters of administration, but you hadn't had me use that term.
Yes.
So where there is a will, it's grant of probate. Where there is a will that doesn't have certain things, maybe it's not valid, or it doesn't, or it has included some property and not included other, or it has not named anyone to transfer the property, because the beneficiaries have no power to transfer the property to themselves. The testator must have named an executor. So where there is no executor, then you should apply for letters of administration and attach that will. And say our father or our mother left behind a will, but there is no one who was given the power to transfer this property to us. Okay. So we would like the court to help us, and you appoint someone who will be able to, and all the beneficiaries must consent to that person, or the administrator general shall come in and administer the property on behalf of the deceased, even when there is a will.
Okay, very interesting.
I know, it's very interesting.
So let me ask, before we cross to the next, when is the right time to write a will?
You should write your will as long as you're 18. The moment you clock 18 years and you have any property, start writing your will. And you have a beneficiary, start writing your will. Because death is not promised. It's only God who knows that. It's only God who knows, and he hid that fact from us. So for even me, I should now go and write my will.
So, but the people do fear. I don't know the sensitizations you're making towards people making wills, but there are some people who do feel that if I start writing a will, it's like I'm calling in death closer.
That's true. But okay, if you're above 50, you make a will.
Oh,
considering our lifespan.
Okay.
Yes.
50.
Prepare that will
good.
and always update it. Keep updating it. Keep updating it until when the Lord calls you.
Okay. All right. Now let's cross over to intestate succession. What does this mean?
So intestate succession, this is where you have died without a will.
Okay.
Where a majority of us Ugandans fall. Most of us pass on without wills. You're not prepared, you've not prepared, and then you pass on. You have all this estate, you have all these properties, but you have no will. So in such circumstances, the Succession Act guides on how this property shall be distributed to the beneficiaries upon your death, because you have not put for us your wishes. So now we shall use purely the law.
The law, okay.
Yes. While here with attested succession, you can decide and give your lion's share of your property to your last child. You can decide and say, this will go to this person. You can, in your will, actually you can even donate your land.
Oh.
Yes. You can say, I have given all my children, but on top of that, I am donating this area to the church, to the mosque, to the government of Uganda, and the children will respect that. But where you have not left a will, then the law shall guide, and we shall look at certain things.
Okay. Well, so who has a preference in the administration in this case?
Where there
is no will.
Where there is no will, usually it is a spouse, a surviving spouse. I need to emphasize to the people that a spouse is someone who is married. Either customarily, you had a customary marriage. For people in Uganda, you have even a certificate.
Okay.
Or there was a kuhinjira, or I don't know in the East how they call it, but there must be a traditional ceremony. Or you were wedded in church, or civil marriage conducted by the district chief administrative officer, or Muslim, there was a marriage in the mosque, or Hindu marriage, all the recognized marriages in Uganda.
How about these people who have been together for like 40 years plus? So they even have children and grandchildren, but they never went for any of those.
So in such an area, the children will have to consent to you, but you will not be recognized as a surviving spouse.
Okay.
But they will consent and say, she was not married to our father, or he was not married to our mother, because it's not just men that have property. Even women have property. He was not married to our mother, or she was not legally married to our father, but we trust that she will administer the estate of the deceased. But where there is a surviving spouse who is legally married according to the marriage laws recognized, then they will be the ones to administer. However, this can also be the beneficiaries can say no, we're not comfortable with the surviving spouse. This usually happens where families are polygamous in nature. Maybe they say, on top of having her as an administrator, we need someone else from another family. So such circumstances happen in such areas, but usually where there is only one, then it should be her.
Very interesting. It is now getting better, and I hope you're picking out one or two things, because these are very, very vital things to note and also implement when the right time comes. They have told you writing a will starts from 18, but of course it has been a challenge. So many people die without wills, and now it's what we're discussing. Of course, we shall continue with that after the short break.
Issues at hand. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. Issues at hand.
All right, welcome back. We are discussing matters to do with the succession law. We did talk about testate, where you have left a will, and of course we looked at how the succession law applies there. Now we are talking about the case if you've not left a will, which is intestate succession. And here with me is Counsel Patra Alinda, who is a legal officer. Of course, that is all from the Judicial Services Commission. It's a pleasure to have you, and we are getting good feedback from the people out there. So we are talking about intestate succession.
Yes.
And now we also looked at what happens in case you live without a will and all that. So who are the beneficiaries under this succession plan or intestate succession?
So like I had said, where you die without a will, the law purely comes into play.
Okay.
Because you have not put for us your wishes, so the law will recognize people that are fit to enjoy, or to have, or to take on, or to enjoy means people are going to come and take on your estate and eat it, and then no, we actually request that people should be able to have these assets and actually even also pass them to their other children. So who are the people that are considered that should benefit under intestate succession?
Yes.
If you have an asset and you've died without a will, one of them is a surviving spouse. That's the first one. The law actually, when you go ahead, it even shows the percentages that shall be distributed to each one of them. But the surviving spouse is one of the people that should enjoy or should have an estate administered to them. So a surviving spouse, like I had said, is someone who is legally married according to the marriage, all the marriages that are recognized under the laws in Uganda. Then we have lineal descendants. Who are the lineal descendants? These are your children, the first in line. These include your child, your grandchild, this in your line of a person who is descendant in a direct line from you, the deceased. So your child, your grandchild, all those up to 6 degrees downwards. So your child, your grandchild, your great-grandchild, your great-great-grandchild can all benefit.
Okay.
The third person is a dependent relative. In Uganda, because we have, in Uganda, most of us find ourselves with dependent relatives. You stay with someone, you're taking care of them. They are not your child, but they, at the time of your death, were they wholly dependent on you. Sometimes you God blesses you with wealth, and you decide, why don't I share with other people? So you go back to your home and you find these people who are around you and they are lacking school fees.
Yes.
And you bring them up in your home and you educate them from senior 1 to senior 6. Maybe at the time of your death they were in senior 5. They were wholly dependent on you for everything that a person must have. Education, food, those are your dependent relatives.
Okay.
Then a customary heir or heirs. Originally, we never had heiresses, but with the amendments, we now know that you can have an heiress who can take on. So this shall also be recognized. Now, if you have a surviving spouse and children and a dependent relatives and a customary heir, that's the line in which they will get. First, it will be the children and the spouse who will get the biggest share, then the dependent relative and the customary heir. Where you have no children but you have a surviving spouse and dependent relatives and a customary heir, it will be the surviving spouse, the dependent relatives, and the customary heir in that same line of preference. So we shall give them the distribution. If you have maybe 30%, if you have 30 cows, we shall distribute and say, according to the law, this is what, but the most preferred is surviving spouse and the children, linear descendants, who include your children, their children, their children's children, until, and then comes to the dependent relatives, who at the time of your death were holy. But if at the time of your death you had gotten a job, you were staying with me, you stayed with me, I educated you, but at the time of my death, you are now out of my home, then we shall not take care of that. But also now, we say that according to the amendments, we are saying that if someone left behind children who are below 25 years and they were being educated or they were still in school, then 20% of that estate should not be distributed, but should be left to take care of these children until they turn 25 or 21 and they finish school, whichever comes first.
Okay.
Yes. But also people who have been married, if someone has been 25 and they are married and they are children, you don't expect to distribute to them the same property as someone who is 16 and still in school. So that is why we say, please make wills so that you can put in your wishes. If you don't put in your wishes, if you don't have a will, then the law shall come into place and have these people. The law actually has the percentages. We implore people to look at the Succession Act. Maybe one day, another time, I will come and teach on these percentages, and people understand what percentage, if this person passes, what percentage may I get if this person has no will. But we also don't want people to kill their parents because they are waiting for
their portion.
You're not entitled, actually. Yes, it's their property. It's only that it's courteous that when they've passed on, this one should be transferred to you to manage.
Okay.
Yes.
And maybe, how about the parents? Because there are some people who get wealthy at a very young age. You find when they are passed, they will unfortunately pass on, they don't have anyone apart from their parents. Maybe they are not yet even married, things like that. Where does that go? Does it go back to the parents or?
Yes, it does.
Oh.
Like I had said, we'll look at if you are wealthy, you have parents, you have no wife or husband, you have no children, you have no dependent relative, then it will go back to your family, to your linear descendants, who are your parents and maybe your siblings.
Okay.
Yes.
Oh.
But the first, before we can go to parents and siblings, the first is your spouse and your children.
Okay. Very interesting. I believe now people are getting things right. So what legal steps must be taken to acquire letters of administration?
Before we can talk about legal steps, let's talk about grandchildren.
Oh.
Because usually grandchildren say, my grandfather had land, I'm also entitled. Yes. So before you, the grandchild gets,
it has to be
your parents in that line.
Okay.
So after your parents, if you're, and depending on the property this person had, then where there is no will, it will first be your parents. Then maybe from the parents to the grandchildren.
But if there is
you don't expect to share with your parents on the same property.
But if there is a will and the grandparent decides to give you that authority, it's very okay?
It's very okay. That's why I told you in your will, you can even donate land and say, I've donated this. I'm not giving all my children. I've donated this land to my grandchildren because my children should go and work hard. And it's okay because those are your wishes and we shall recognize those wishes.
Maybe one question. Why do people find it hard to respect the will?
People find it
so hard to get land. Why?
People find it hard to respect the will because we don't trust. And people have not been signing these wills. So someone will write a will, and of course people will say, that will must have been written by someone else. That is why now we are saying when you write this will, make sure you sign it on every page. And make sure you have at least 2 witnesses who either saw you signing it, or you informed and said, I'm sending you my will, my lawyer is coming to meet you. It's actually me who signed it. And they should also acknowledge and sign just after you've signed that this person has made this will. But originally people would make wills. These wills are not signed. So why would I trust? Even me, I would wake up tomorrow and make the will. And that's why you find people used to have so many wills around. But now when it's only the confirmation that it's valid, did this person sign? Because remember, we are taking effect. Its effect starts after death. So they definitely cannot sign when they are dead. So did they sign? Yes. Did it have witnesses? How many? If it's 1, it's not valid. There should be 2 or more. You can even have 5 witnesses. But the least number should be 2. And they should be on every page. So that there we shall say, okay, this will is valid.
Okay, that's great. So let's go to the legal steps of acquiring letters of administration.
Yes, so once someone has passed on, there is no will. The first thing that happens is they have to invite the Administrator General. Usually when we go to our districts, they usually send town clerks. The town clerk will represent the Administrator General. So the Administrator General meets with the family. The family has to appoint who is going to be the administrator, and we shouldn't confuse an administrator for a customary heir. Omska cannot be an administrator, except if the family has actually said, you know what, let's allow this person to administer this property and transfer it from our late father or mother to us. So the beneficiaries must consent. That meeting, they will come up with minutes, and then they will consent that we actually acknowledge that we have appointed this person to become our administrator. Administrator can be 1 up to 5. You can have 1 administrator until 5 administrators. That's what the law provides. But most importantly, you must have a death certificate to confirm that actually this person died. Otherwise, why are we transferring an estate when we don't have confirmation? After you have had the certificate, the death certificate, and invited Administrator General who has conducted this meeting where you have sat down and confirmed the property that the person left behind, you have confirmed what this person, who the spouses are or spouse, who the beneficiaries are, all these things, then you will apply to court, and the court will be able to review and grant you letters of administration. And once they've granted you letters of administration, that is when you can administer and distribute this property. Other than that, you're not supposed to distribute the said property.
So what are the duties or roles of the administrators?
Most people run to be administrators and have letters of administration, or executors and have grants of probate. But we need people to know their roles. If you're running to be an administrator of an estate of your deceased brother and you want to administer on behalf of the children, or you're the wife, you shouldn't hold this property. And some people hold the property and it even becomes theirs, and it even becomes the property of their children.
Of their children.
Yes, that's wrong. So first of all, you have to ensure that you collect all the property of the deceased, find out all the property that belong to this deceased. Did this person have money in an account? Did this person have property? Some people invest in towns and invest also in the village. So you have to find out. Now we invest, you find you have property in Bale, you have property in Gulu, you have property in Kampala. The administrator or executor must find out and establish all that property. 2, the administrator must pay the remaining debts that came from the funeral. The administrator, now when you have the letters of administration, you must file an inventory with court within 6 months. This is very key. Once you have gotten letters of administration, please file an inventory with court to show the progress. Have the property been distributed or not, and give reasons why such property has not been distributed as yet. And after a year, you should also file an account on the property that you have, so that court knows the property that we put into the hands of administrators. Are they actually using them to the interests of the beneficiaries or not? Most times we have a tendency where the administrators are old and the beneficiaries are young, and the administrators sit on the property and they end up using them to their advantage. So we are saying the law actually says that that is wrong. So you should be able to file an inventory within 6 months to show court the progress of this estate that you were entrusted with, because court has entrusted you with this property. And also after a year, you show, have you completely distributed all the property or not, and why haven't you distributed all the property? Because if someone passed on a year just last year and it's October, why isn't his property? Maybe that's when you have reasons and say, most of the beneficiaries are still in school, so we have reserved 20% of it to be able to sustain the children while they're in school.
Okay.
So administrators should do these things, otherwise they are violating the laws that have been put in place. And most people actually do not. They run, get letters of administration, and after that they sit with the property. And then even the beneficiaries have to bench. They have to plead with them, please, this property is ours, this was our father or mother's property. And the administrator is just there seated, and then you find they are enjoying the sweat of the beneficiaries. Yes. The property that should be with the beneficiary is now with the administrator. So those are the roles.
Is there provision for terminating these letters?
Yes.
Court can terminate.
Yes, and now actually with the new amendments that came in 2022, these letters now can expire after 2 years.
2 years.
So when you get letters of administration now, after 2 years they'll expire, and you can apply to court for renew. But applying to court for renew must have consent of the beneficiaries, because one of the questions will be 2 years later, why is it that the estate hasn't yet been distributed? Then that's where you'll give reasons and say, look here, the beneficiaries are still young, they're in school, we cannot distribute all the estate. But if you do not have such valid reasons, then, or even the child or the beneficiaries will be asked for their consent. Should we give this person other letters of administration? And court has the powers to say, okay, we're only giving you 1 month. They renew them for 1 month or 4 months or whatever period of time they think fit for you to be able to administer this estate and have it distributed to the rightful owners according to the laws of Uganda.
Okay, maybe one question is, when it comes to these people who die without wills, you find people occupying premises immediately when these ones die. So whose mandate is it to make sure this property, which was not accounted for maybe by the deceased, whose role is it to bring it back to maybe the family or whatsoever? Is it the administrators now?
Did you say that the person had property, but it wasn't known by the
Yeah,
beneficiaries?
it wasn't known by the family members or beneficiaries.
And there was no will.
Yes, there was no will.
So who is aware that this property actually belonged to this person?
Maybe friends, maybe what?
Now you see that's tricky because friends, they should be, ordinarily it should be an administrator to ask the friends. That's the role of an administrator.
Okay.
To sit down and ask all the friends of this deceased, ask the spouse of this deceased, or if it's a spouse, ask the friends, do you know any property? Or look for all the property, and then you collect it and then have it, and then you can distribute it. So it's the role of an administrator. So that's why it's best that an administrator must have known this person so well. Because then you know that this person had property in this and this area, but also you must have the best interests of the beneficiaries. Usually the beneficiaries are children who are young. At least where children are old, they can always fend for themselves. But sometimes you find that the beneficiaries are young. So you as an administrator, you must have the best interests of these beneficiaries, so that you say, okay, this is their property. I'm not going to hide it. I'm going to inform them that your father had or your mother had property here which you are not aware of, and include it among the properties to be distributed.
Okay. Part of the roles is to pay debts. Can you make me understand this?
So
you pay the debts of the deceased using your money or
using part of the estate.
Okay.
Yes. So once, it's a culture that in Uganda, once someone passes on, we have funeral, and then all the expenses. They are quite heavy for most people. So at the time, people may contribute for you condolences, but sometimes the condolences may not be enough. So what happens is, after they've collected all this property, they should be able to say, did this person maybe leave behind money that we can use to pay off? Because that's why we work. So once they have removed the money or part of the estate, but they should consent with the beneficiaries, should sit down with the beneficiaries and say, your father left behind this and this estate. However, these are the debts. Do we consent to get off from this estate and first pay? Because you cannot distribute the estate before you have completed payment of the funeral expense debts. Sometimes, this person actually passed on and they had a debt they had a loan. They had purchased land, but they had a loan which they were servicing and they had not yet fulfilled. So you as an administrator, it is your role not to pick from your money, but to pick from the estate. But you must sit down with the beneficiaries and understand and say, this money or this estate, we are going to use some of it to pay this loan that this person was servicing at the time of their death. So the money is not from you. It's not from your pocket. It's from the estate of the deceased. All
right. Well, thank you so much. It's been a pleasure, and you have done us really well by elaborating out all these things and simplifying the language.
I hope people have learned one or two things.
True. All right. So maybe as we wind up, you could give us your parting shots that we can move out of here.
Fellow Ugandans, everyone who is watching, I know that managing estates is quite a hard thing, but I hope that we will be able to go back and put these things in an orderly way. You can talk to your parents, or you can advise, or you can teach some of the things that you've learned from our topic today, because succession is something you cannot really run away from. It may not be you today, but it may be your neighbor tomorrow. So we hope that in our day-to-day lives we shall respect the law when we are dealing with succession matters, when we are dealing with managing estates of the deceased. And we thank Family TV for giving us an opportunity, and Judicial Services Commission continues to pride in preparing programs to educate the public on land administration of justice. They can find us at Kingdom Kampala, or they can call us on our toll-free line 0800 100 222 in case they have further questions on the said topic.
Thank you so much. It's been a pleasure to have you. And I strongly believe you have also picked so many things from what we've discussed, but only pick those that are very helpful to you because it is very important. But aside of that, I want to appreciate you as well for giving us this information, moderately to our audiences out there, because it is very important to have some knowledge about the law and what is required in that regard, because so many people have been framed, people have been conned because they are ignorant about the law. So that's why we appreciate. Otherwise, colleagues, before we wind up, I want to bring unfortunate news: the passing of the former Prime Minister of Kenya, that is Raila Odinga. He has died at 80 years. That was in India. We shall be bringing you much more information in that regard, but may his soul rest in peace. Have a lovely day. My name is Luke Majumba Lenaitwe. More programs are coming up, including the Uganda We Want.
Issues at hand. This is Church of Uganda Family TV.